Dear all, welcome to this presentation. I am Cristina Casas. I am founder of Casas Assin, intellectual property law firm in Spain, in Europe. And first of all, I would like to thank you all for being here, sharing with us your experiences, thoughts, and comments, and of course to the organization of Well IP Forum. I've been participating as a speaker since the beginning, and they have done a great job organizing it one more year in these weird circumstances. So, first of all, my congratulations to everybody that can be here with all of us today. Today I'm not gonna be a speaker, I will be moderator of a great panel. The topic will be protection and challenges of IP assets in the post-pandemic era. And I've been working closely and so hard with my colleagues from different countries because the idea is that all of us can have a general overview in how we have been affected from an intellectual property point of view by the COVID-19 or coronavirus. We're going to analyze different point of view in different countries. We will have from Latin America, Mexico and Brazil, and the US as well. First of all, our first speaker that I would like to thank the participation of all of them and congratulate them for their work is Mônica Nogueira from Brazil. Mônica Nogueira is a lawyer and as well the founding partner of MNIP in Brazil. She is a team management and client handling, and she has been the person in charge of very big companies across the world in different industries. Mônica's expertise and a strong academic background comprise international and Brazilian trademark law and fair competition and enforcement rights. She has studied in Brazil and a Masters of Law in Intellectual Property in London, the University of Queen Mary in England, and a specialization in copyright issues in Spain, and of course her bachelor in Brazil, her own country. So she will be sharing with us how this situation have been handled in Brazil. We have other point of view in Latin America. This is our speaker and great patent engineer, Tomasz Arankowski. Tomasz is a partner and a founding manager of the Mexican IP law firm AVA. He had a study at the University of Panamericana in Mexico and is specialized in industrial properties. He is professor as well. He's teaching IP in different master's degrees. So it will be so interesting. And finally, our third speaker, she is from the US. She is Mariana Noli. She's the founding partner of Noli IP Solutions. After becoming attorney in Argentina, she was starting to work in IP law firm in California. And in 2014, she founded Noli IP Solutions. That it's a small, diverse, and inclusive intellectual property law firm located in North County, San Diego, in California. She founded as well, because she is very active, the non-profit organization Women's IP Today in 2015. And she currently serves as president of the Italian American Lawyers Association of Los Angeles. So as we can see, all our speakers, they are quite active in intellectual property. They work very, very hard, and it's my honor to introduce them in this Well IP Forum edition. I hope you enjoy, and after the presentations you can contact us, as you already know, and please ask us or share with us your experiences, thoughts and comments. Finally, I'm sending our best regards from Spain in Europe, where we have been having a very hard time with this COVID-19 from the health point of view, and as well how the companies has been suffering the close of the establishments and shops and everything. But I think the focus and our objective is always try to help and support our clients, trying to put in value their innovation and their creations. So anything all of the speakers and I am as a moderator, we can help you or you want to share with us, we are more than welcome. Thank you again for being here and attending this WellIP Forum and the organization as well.
Hello everybody, this is Mariana Noli from the state of California in the United States of America. I have been asked by my colleague Cristina to provide with a short overview of how our practice has been affected and impacted by COVID-19 and the pandemic. Just a little bit about my background. I'm an intellectual property attorney. I specialize in prosecution and litigation. I help with transactional and licensing as well as some enforcement. So I can give you a little bit of an overview of what has happened as well with the court system, not only on the prosecution side, but also on the litigation side. I became a licensed attorney in Argentina in 2003 and an attorney admitted to practice law in the state of California at the end of 2006. I ran my own practice in California. You may recall that on March 13, 2020, our then president declared the state of emergency. And early on, we started to receive notifications from the United States Patent and Trademark Office indicating that if there were deadlines on your previously filed applications that you couldn't meet due to COVID or applicants could not meet because their businesses were affected by the implications of the COVID-19 pandemic, that you could be excused if you explained the reason. So there was a little bit of flexibility as far as the deadlines if you could not meet a particular action requested because of the pandemic. As far as the patents, the United States Patent and Trademark Office, of course, had as a priority the treatment of the virus, and it did create a mechanism to expedite the examination and prosecution of the patent applications that related to inventions for the treatment of the COVID-19 virus or the SARS virus. That is on the prosecution side. You could be potentially excused for not meeting the deadline, not losing your application. Your patent will get priority in line for examination if it related to an invention. Also on the copyright side, the United States Copyright Office, which is a separate entity, the United States Patent and Trademark Office, and it depends on the Department of Commerce, issued early on very similar notifications, making sure that applicants, if they could not meet a deadline because they were affected by the COVID-19 pandemic, that you could file your excuse or explain that to the examiner and you could be excused for not meeting the deadline on time. That happened on the prosecution side. In a way, we were very fortunate that in the United States, it's already fairly advanced when it comes to the electronic access to the platforms of the United States Patent and Trademark Office for patent and trademarks, as well as for copyrights. Everything is filed electronically, whether it is the initial application, a response to an office action, submission of specimens of use. So everything is already done online and not in person, as I know in other offices around the world is done in person. So that was not affected. Now, as far as litigation, and of course in litigation matters is a little different. Not sure if you have experience litigating in the United States, but you have two courts, state courts, and the federal courts are district courts, depending. Oftentimes when we're dealing with intellectual property, we're dealing with the federal court system. And the courts are also fairly advanced in their online system of filing. So it's easy to file a pleading, and it's easy to file an answer to a pleading. But of course, the court system was affected more significantly with the COVID-19 pandemic because trials were suspended. They didn't give civil trials, which would be intellectual property priority. Criminal trials were a priority. So criminal trials were suspended for 3 months. That created a backlog. And the civil trials, at least 3 months, and the civil trials were not the priority. So when the federal courts restarted their activity, it was already a pretty big backlog. There are still some difficulties because here in the United States we have jury trial. The courts have to follow very strict guidelines. So as far as the filing, there were not many issues because we have the electronic system of filing. But as far as scheduling a hearing or taking depositions or being in the court, all of that was significantly affected by COVID. Yes, it's true that you could take the hearings via Zoom, electronically, WebEx. Yes, it's true that you could have a hearing or a meeting with the judge. But as far as the jury trials, there is a significant backlog because of the pandemic. I have to say that I think that there are constantly rules that are helping us to catch up with that backlog, but that is the reality on the federal side. And it makes sense that the civil cases that relate to intellectual property are not the ones that had the priority very early on. I will just summarize for you how has COVID-19 affected intellectual property rights in my country, in the United States, as far as the trademarks, the prosecution of trademarks before the USPTO. There were rules allowing applicants to be excused for meeting deadlines if it was because your business had been affected due to COVID. As far as patents, if your invention related to a vaccine or to the treatment, cure, investigation, anything related to the SARS virus and to COVID-19, there were mechanisms put in place to expedite the examination and grant of your patent. For copyrights, very similar to trademark applications, there were rules that made sure that if you miss the deadline because you were affected by COVID-19, that you could potentially be excused upon the submission of an explanation when the time came due. And for the litigation matters, they were suspended depending on the court. State and federal were not exactly on the same timeline, but you could have certain meetings via Zoom or WebEx, but there were no oral trials scheduled, especially jury trials, because the courts would not want to put in danger individuals. I hope that helped. with an overview of how COVID-19 and the pandemic has affected IP rights in the United States. And I have to say that thankfully we were already very advanced in the use of online platforms for intellectual property and also for other areas. For us personally here at Noli IP, we've been working remotely since the pandemic started, and our president declared a state of emergency on March 13, 2020. And since then, we've been working virtually to keep our members safe, and hopefully we'll be able to overcome the implications of this pandemic very soon. Stay safe. Thank you again, Cristina, for this invitation. And thank you everybody at the World Intellectual Property Forum for inviting me as well. Stay safe, and I hope to see you very soon in person.
Good morning or afternoon for those watching. Thank you for having me. My name is Monica Nogueira, and today I'll be talking about the IP challenges and protection in Brazil. I'll begin this presentation by giving you a brief summary on the number of IP applications in Brazil in 2020. Right after that, I'll give you an overview on Brazil's IP backlog situation. I'll tell a bit of the major international agreements Brazil has recently joined or will probably join in 2021. And to wrap it up, I'll give you an overlook on the expected IP scenario for 2021. I'd like to begin stating the obvious. 2020 was the year of the pandemic, a pandemic that was and still is more than just a health crisis. It's also an economic one. With the rapid increase of COVID-19 patients in early 2020, major urban and economic centers in Brazil declared lockdown. That was in late March. The lockdown drastically affected the GDP of the second quarter, reducing it in almost 11%. Although the GDP gradually recovered from this collapse over the following quarters, the country is still adjusting to the new scenario. Together with the GDP collapse, IP applications also saw a significant decrease in Brazil as expected. Total IP applications, considering only brands, patents, and industrial designs, dropped from over 21,000 to less than 17,000 between March and April of last year. Such decline represents a 22% setback. Among the three referred IP categories, brands make up most of the IP applications in Brazil. It is also the IP category that suffered the biggest blow, together with industrial designs. Nearly 23% decrease was registered in brand applications, which is equivalent minus 4,200 applications approximately. Fortunately, the following 3 months closed with exceptional increments, which averaged around 28%. Because brands represent most of the IP applications, this increase caused the application total to rise as well. Despite the momentary decline, the average number of IP applications from November 19 to October 20 still displayed a 7.8% overall growth when compared to the same period in the past year. As I have highlighted, each IP category responded differently to the economic slowdown. Difference in their responses may be due to the contrast in their applicants' profile. Brand and industrial design applicants are made up mostly of Brazilian residents, more precisely, Brazilian micro-entities or individuals. As an effect, such applicants are more prone to be affected by shifts in the national economy. On the other hand, that is not the case for patent applicants, which comprehend mainly non-residents. Moreover, the few percentage of resident patent applicants includes a considerable chunk of entities with public source funding, such as public universities and other R&D institutions. Because public funding is usually less volatile, a major part of patent applicants did not suffer immediate budget cuts during the economic shift, managing to go through with their applications. Now, let's take a step back and look at the track record of the past 7 years. Notice that the overall number of new IP applications has been steadily increasing since 2015. In particular, brands have displayed a major growth since 2016. Also, although data from 2020 is incomplete, lacking numbers from November and December, the total IP applications already exceeded those filed in 2018. This suggests that further increments are likely to happen. Considering the growth trend since 2015, we expect further growth on IP applications in the years to come, despite the pandemic situation. According to the Brazilian IP Office, brand applications should increase 31%, patents 27%, and industrial designs 15%. Other factors that may play an important role in such outlook are the international agreements and treaties, which I'll talk about a bit further on. If the expected is a larger input of filings, the Brazilian IP Office must also improve its output capabilities, which is what I'll be talking about next. Unfortunately, the Brazilian IP Office is known for its excessive long examination time. A patent examination and decision, for example, could take up to 7 to 10 years. Even so, the progress that has been made on IP backlog reduction is undeniable. For instance, over the first half of the past year, the Brazilian IP Office managed to communicate more decisions than the number of received brand applications. On July, however, the rhythm got slower, and the number of applications eventually surpassed the number of decisions again. Nevertheless, the waiting time for the first examination decreased almost 75% over the past decade, which represents over 307,000 first examinations. Although 2020 had accumulated 285,000 applications and just about 270,000 decisions, the Brazilian IP Office expects a 29% growth in decisions in 2021. In the case of patents, backlog reduction has been key to many of the Brazilian IP Office efforts since 2017. However, it was only in 2019 that a major task force was deployed under the name Combate ao Backlog. According to the Brazilian office, the country's patent backlog should reduce 29% the original backlog from August 19, which accumulated almost 200,000 applications. In 2020, the number of decisions made per month was almost 200% higher than the number of applications received, so it is far to expect that further decreases in the present backlog in the following years will occur. One of the main tools that allowed shortening of examination and decision time was the procedure 6.21, which was implemented in late 2019. This procedure basically facilitates the examinations of inventions already examined by another IP office. When receiving a foreign application, the Brazilian IP Office issues a 6.21 OFT action, which presents a list of state-of-the-art documents identified by the foreign IP Office during examination. The applicant then will have the chance to amend the application according to its foreign counterpart. If such amendments are presented and all formal criteria are met, the application will benefit from simplified examination with higher deferral chances. Solutions like this were implemented to avoid redundant examination and encourage foreign applications. So, up until now, I've talked about the input and output number of our IP systems in 2020. Now, I would like to go into the initiatives intended to plug the national system onto the international IP environment. The first international system I'd like to talk about is the Madrid Protocol. Since the adoption of the protocol in late 2019, almost 13,000 foreign applications having Brazil as designated country were received, most of brands' applications coming from Europe, USA, and China. Brazilian brands have also benefited from the system, gaining access to 124 participant countries, which represent 81% of global GDP and 72% of global population. The adoption of the Madrid Protocol also motivated the Brazilian IP Office to review and speed up all trademark examination procedures, substantially reducing the time frame for issuing decisions. Brazil also intends to join the Hague Agreement for Industrial Designs in 2021. This agreement enables protection of an industrial design through a single international application. One of the main advantages of this system is the simplification of multinational application and cost reduction. Joining the Hague Protocol would also result in great reduction of decision time and in a considerable increase in applications. The last international system I'd like to mention is the Budapest Treaty, which Brazil is likely to join also in 2021. This treaty enables international registration of microorganisms related to patent applications. By doing so, this treaty provides a more robust patent protection, especially for biotech patents. By joining the Budapest Treaty, Brazil would have the chance to unlock the international potential of its biodiversity-related IP, while safeguarding its biodiversity. Because Brazil holds approximately 20% of the world biodiversity, this kind of deal may be key to the country's economic development in the upcoming biotechnological era. To sum up, I'd like to highlight the trends and expectations for 2021. IP application numbers are indeed expected to rise in 2021, despite the pandemic lockdown and economic slowdown. Brands will likely show the highest growth rates, averaging around 31% annually, followed by patents, which rates are expected to grow 27%. On the output side of the coin, Brazilian IP Office intends to keep pushing down the overall IP backlog. In 2021, the patent backlog is expected to reduce to 80% of August 19 original backlog, and decision times shall reduce 23% compared to last year. Same reductions tend to be seen for brands and designs. Moreover, the Brazilian IP system will enhance its connection with the international IP environment. Some worth mentioning initiatives are the Madrid Protocol for brands, Hague Agreement for industrial designs, and Budapest Treaty for patents. With that, I conclude my presentation. It's been a pleasure to be here with you today. For those interested in talking a bit more about IP in Brazil, please feel free to contact me via email. Thank you for the invitation and have a nice event.
Hello, greetings from Mexico. My name is Tomas Arankowski. I'm an IP attorney and I am the co-chair of the IP practice at ABA Firm. I want to start this conversation by thanking my dear friend Cristina Casas for her invitation and for allowing me to share this panel with an stellar group of colleagues. Likewise, I want to thank the World IP Forum for providing us with this extraordinary platform that allows me to reach out to you and talk a little bit more about what's going on in IP in Mexico. The COVID-19 crisis came with huge challenges. I fear that we are far from actually knowing the real depth of its consequences, and of course, IP is no stranger to these challenges. Early on 2020, the Mexican Congress started the discussion that ended up with the publication of a new law, the Federal Law for the Protection of Industrial Property, that came into effect in November 5th, 2020. This new legal body governs all IP rights in Mexico except from those related to copyrights. And this new law is also the result of the negotiations of our country with the United States and Canada of what we now call the USMCA, the United States and Mexico and Canada Agreement, or USMCA, or as some would call it, NAFTA 2.0. Of course, as it should be expected, this new law comes with a great number of changes that will be interesting to see moving forward how they are applied by the Mexican Patent and Trademark Office. In the world of trademarks, for example, the law changes the way in which we will be counting the life of trademarks. In the past, we used to count the 10 years, which remain the same now, but we used to count their life, those 10 years, from the date of filing of the application. Now, we're going to count those 10 years from the date of grant. Another important change that came with this new law has to do with the fact that we now have to file mandatory declarations of use. The obligation to file these declarations of use was enacted in Mexico back in 2018. However, at that time, it was unclear of when or of which applications or registrations were actually obliged to comply with that obligation. Now it is very clear. All trademark registrations granted after August 10, 2018 need to file a mandatory declaration of use in order to maintain rights. This declaration of use has to be filed within the 3 months following the 3rd anniversary of registration. It is also important for you to know that this obligation applies even if your mark comes or derives from, or your trademark registration comes from an international registration, the Madrid Protocol. If you are using or selecting Mexico as one of the countries where you want to file an international mark, then be aware of this obligation if your mark was registered after August 10, 2018. Another important thing that has to do with trademarks is related to, trademarks and the declaration of use. In the past, the Mexican Patent and Trademark Office was very flexible when it came to the renewal of trademarks. Because basically, the way the prior law was written allowed for a company to maintain, or a trademark owner to maintain rights even if in 100 products when it only in fact was using one of those products. Now the law has changed. The law now requires that when you are entering the mandatory declaration of use, or when you are renewing your application or your registration, you need to file and state on the road which products are you using, which products or services you are actually using, and all of the rest will be considered as disclaimed. Therefore, the trademark owner will lose any rights over those products. This is a major change that will pose interesting challenges moving forward, because in the past it was a common practice in Mexico, for example, to file for trademark applications covering, for example, the class heading. Now we're going to have some changes. Also, I think it's important to mention that there are some changes that has to do with the well-known status of marks. Since 2013, or more or less that time, the law changed to include a proceeding, and a specific proceeding by which you can actually attend or file before the Mexican Patent and Trademark Office a request for a declaration of well-known status. This proceeding has been changed several times, but the way it's now written on the new law is far more flexible than it used to be in the past, as it requires for less. It has a lower burden of proof, and of course, I think it's an interesting tool for those companies or trademark owners who hold trademark rights over a well-known mark in our country. In short, having an official declaration of well-known status will allow the trademark owner to impede the registration of marks that are either identical or confusingly similar to that granted in all classes. Therefore, the protection is very good. This official declaration of well-known status remains valid for 5 years. It can be renewed, provided the conditions that gave birth to the declaration of use or the declaration of well-known status remain. Therefore, it's a very powerful tool. In the world of patents, the law has implemented a lot of changes. I think one of the most important of them is the inclusion of the Bolar clause in our legislation, which will allow for the use of patented medicines for the purpose of creating the necessary information to file for authorization for sale of medicaments or medicines in our country, therefore allowing for the introduction of generic drugs faster. It's something to consider. Now we have also a provision that forbids the filing of divisional patent applications that derive from another divisional application. This is of course questionable in terms of the Paris Convention. However, we haven't had the chance to actually test its constitutionality or the legality of that provision, because this issue will only apply for patents or patent applications that were filed on or after November 5th, 2020. Another important thing to know in terms of patents, for example, is that we have now implemented in the law the existence or the possibility of the Mexican Patent Office to use PPH or patent prosecution highways. In the past, it was possible to do so, but the legal foundations of that proceeding were either regulations or agreements or institutional agreements. I mean, it was not on the law. Now it's an statutory right. Likewise, we have the chance. This new law introduced a complementary the chance to request the Mexican Patent Office for an extension of life of your patent by means of a certificate of by means of a specifically designed certificate that the patent life will be or can be extended for up until 5 years, provided there are irrational delays from the Mexican Patent Office on the prosecution of the application. This, of course, this certificate will only be available, of course, to those patents or patent applications that were filed on or after November 5th. But of course, it will bring an interesting way in which the Mexican Patent Office will have to approach the prosecution of patents moving forward. And I think if that is worth having that on mind in case you have patent being prosecuted here in our country. Last but not least, I think we need to talk a little bit about litigation and enforcement in general. Now, this new law came with a very important increase in fines. Now, an infringement the infringement of any IP rights that are governed or protected by this new law can cost up to $1 million, $1 million, and of course that's a lot of money. It's 10 times more than it used to be in the prior legislation, more or less. And there is also an important change when it comes to the possibility of claiming lost profits and damages. In the past, it was you needed to your infringement action before the Mexican Patent Office to become final, to then start another proceeding 4 years or 3 years and a half, almost 4 years after you started the litigation. You have to start a new proceeding before a civil court to claim lost profits and damages. Now you can do that at the same time. File for infringement before the Mexican Trademark Office or the Mexican Patent and Trademark Office, and file for lost profits and damages before the civil courts. This is a major change, of course, in the practice, and although it has its good parts and its questionable provisions, it's a step forward in the right direction in order to ensure the real enforcement of IP rights in Mexico. Last but not least, of course, in this topic, we need to talk about the fact that this new law has expanded what is considered to be a forgery, a trademark forgery. In the past, as it happens today, forging a mark, it's a felony. It's a felony that is punished and fines and etc. But it has also includes or implies jail time. So now, in the past, in order for the authority to find existence of a forgery and therefore indict, there has the falsified good or the forged good had to reproduce the mark exactly as registered. Now the scope has broadened a little bit, so even in cases where the mark is not exactly reproduced on the infringing good, it is possible in certain cases to find the existence of a forgery. This will, of course, enhance the chances for protecting trademarks in Mexico. There are other changes that had to do with denominations of origin, collective marks, industrial secrets that are very interesting, and I'm pretty sure that we'll have the chance to further discuss these changes in the future. In the meantime, I want to conclude this very brief introduction or presentation by thanking again my dear friend Cristina Casas, thanking the World IP Forum, and above all, thank you for your time and thank you all for your attention. Talk to you soon.